Hello, everyone. I'm Alex Kukulici, president of FSU Mock Trial 2014-2015. I'm here with Matthew Covert, president that preceded me, Daniel Krepsch, his roommate, our teammate and competitor back this past year in the Rocked World case and prior, and we're here going to be talking about rules of evidence as we have been. This episode is about Rule 701. It's about opinion testimony, specifically opinions by lay witnesses. So I'm just going to read the rule. It's quite short. I'm going to share it on my screen right here, and we'll dive right in. And don't worry if you didn't understand what a lay witness is or you're lost. We'll obviously try and do our best to explain all the facets and the jargon that we're using in talking about it. So Rule 701, opinion testimony by a lay witness. If a witness is not testifying as an expert, testimony in the form of an opinion is limited to one that is A, rationally based on the witness's perception, B, helpful to clearly understanding the witness's testimony or to determining a fact at issue, and C, not based on scientific, technical, or otherwise specialized knowledge within the scope of Rule 702. So I guess first things first, determining the distinction between a lay witness and an expert witness for those who might not understand that jargon. Krepsch, can you just, I don't know,
Sure.
enumerate that distinction for us?
So there are really two classes of witnesses for the purpose of the 700s. There are expert witnesses and there are lay witnesses. I guess starting with expert witnesses have some kind of qualification, some kind of knowledge, something that makes them a very special witnesses in the eyes of evidence. Something that allows
regards those qualifications. You just mentioned experts must.
And that would be Rule 702.
Got it.
So experts are kind of special because they're allowed to delve into really technical, special items of interest. Any witness who doesn't have those qualifications that are in 702 is a lay witness. A lay witness is just talking about, what they saw or what they heard for a particular case. Maybe the parent of the deceased or the parent of the defense or defendant. Maybe someone who overheard a defendant talking about committing a crime or doing something with the murder weapon. Maybe someone who just walked in the door while a murder or some other crime was happening and can testify about that.
Can I guess you distinguish that from what an expert might look like? Don't delve too in depth as to what the qualifications might be, but so those are all examples of people who would be lay witnesses for this rule. But what about an expert?
So an expert would be someone who has qualifications to talk about specific elements. So, for example, in this case, someone who's qualified in forensics and who can talk about fingerprints that might be found on a gun. They have the qualifications, the skill, the knowledge to talk about fingerprints on the murder weapon the way that a lay witness does not. Another example for this case is a child psychologist. A child psychologist can be qualified as an expert, and in doing so they can talk about certain factors that go into child psychology, how those might play out in a specific circumstance, and how they relate to a murder. A lay witness can't talk about the state of mind or the psychology of someone else because they're not qualified to do that.
So just to be clear before we move on into explaining these three prongs required for opinion testimony, and as I said before, and as the rule states, it's specifically for lay witnesses, it's important to be clear that all three of these prongs must be necessary. It's not if one is present and the other two aren't, that doesn't fly. All three must be present. Luckily, they're not too difficult to get, and we'll just go through one by one and explain them. Before we do that, though, you look like you had something covert?
Yeah, I think the general gist of what Dan was saying was there are experts who usually are paid, not always, who have a certain skill, training, expertise to opine on the material facts, and then there's everybody else. there are just two groups of people. Either if you're not an expert, you're a lay witness. There are no types of witnesses that lay in the middle there.
Yep, and it requires some sort of specialized training, and funnily enough, we'll kind of have a sense reading through this rule what qualifications an expert might need. So let's dive into the first prong. It's rationally based on the witness's perceptions, this being the opinion. The opinion is rationally based on the witness's perceptions. There's two operative legal words here, rational and perceptions. We might have ideas of what those mean, but again, they're legal terms in this case, so it's important to have a good definition of what they are. If something is rational, well, it can mean two things. One, that it's based on something that is reasonable, something that follows logically from what the perception is. So, if I see that a wall is white and has been painted blue, and then my opinion is that because the white wall was painted blue, it's now going to explode. That's not a rational conclusion based on that perception. So the conclusion has to be rational. It has to follow from the perception that it was based off of. And a perception is, as I mentioned, so that was an example of seeing something occurring, the white wall being painted blue. Anything that can be experienced by the senses is something that could be perceived. So if I can see something, hear something, touch, taste, smell something, those are all perceptions that go into eventually drawing a conclusion from them. If you've listened to our speculation podcast, you might have made a distinction here, not a distinction, but you might have made a connection between the two rules. The two are very similar. Namely, when someone speculates or does not have the requisite personal knowledge to reach a conclusion, they either are making an irrational conclusion and or they do not have the perceptions requisite to make a conclusion, whether it's rational or not. So something in this rule has been broken when speculation occurs. That means that in a lot of cases, either rule can be used, although generally when we go through trial, 701 is used in regards to 701C and special scientific and technical opinions, and those are improper opinions as they're colloquially dubbed, and speculation or lack of personal knowledge is used in instances where a witness is opining irrationally without the requisite perceptions, although that obviously has its basis in 701. Just know that they're connected yet distinct in some ways, and when we tend to use one or the other. Do either of you have anything else on 701A, specifically the definitions of rational and perception?
I do want to go back to my example about London Bennett and the car.
Yes.
Because I think the recovery from that is a perfect example of what a rationally based perception is.
Correct.
So when I objected to London Bennett testifying, the car was going 55 miles an hour. Objection, speculation, improper opinion, whatever I said, right? I won. They came back and said, well, Miss Bennett, from your standpoint, from your vantage point, what could you see? She said, oh, well, the car was going really fast. Now, that's okay, because it doesn't take some sort of specialized technical training to know that a car is going really fast. It would be improper to say specifically how fast it was going, but to say it was going really fast as something that she could see, she could feel, she could perceive based on her perceptions, and the inference that it was going really fast can be rationally based. So that's sort of a good example of something that an expert can say, okay, it was going 55 miles an hour based on X, Y, Z, but a lay witness can say it was going really fast. So that's sort of the example of it.
What are the example of the standard of what is a perception that is rationally based? So that is some sort of bar that needs to be cleared. The perception needs to be based in reason for it to be useful. So in that car example, what's the type of thing that you could feel that is rationally based? Because you can't just say, oh, well, my dog started barking, so the car was going very fast.
Right.
That doesn't follow rationally. Like that, you might have perceived your dog barking,
right,
and that's fine, but that's not a rational conclusion to draw.
Right. So in this case, like with all testimony, you have to lay foundation for it. You have to demonstrate to the members of the jury or your judges in the context of mock trial of what are the perceptions the witness has had prior to that or contemporaneously to that allow the witness to have that that rationally based opinion. And what London Bennett could say is a few things. One, I'll give you the facts of her specific testimony, the best to my knowledge. So she lived on that road her whole life. So she can testify, I've seen hundreds of thousands of cars coming down this road. I know what all those speeds look like. I sit on my front porch all day and I watch these cars go by. And this car was going significantly faster than any car I've ever seen. Therefore, it was going really fast. It was raining. I could see that the car's back tires were sort of, wobbling out of place. So it was hydroplaning. So that was evidence it was going really fast. Still doesn't allow her to say it was going 55 miles an hour, but there's some testimony to show how fast it was going. Maybe the car was going so fast that it blew by and opened the mailbox. That's never happened before.
Sure.
Stuff like that is foundational evidence for her rationally based perception, but it still isn't sufficient for her saying, okay, it was going 55 miles an hour. So like anything, there has to be foundation for the witness's testimony.
Perfect. I think that's pretty much a very good example of the distinction between what is an expert testimony and not, and we'll get to that a little bit more specifically when we talk about 701C, and even more better example of what is a rational perception, what is a rational opinion based on certain perceptions, what type of perceptions qualify for this. It's a low bar, but there are some witnesses who will get up there and say unrelated things, say things that are too significantly disjointed to be able to draw rational conclusions from. So it's important to establish the types of things that can be used in that example. If you're having problems with that, just treat it on a case-by-case basis, but in general you can assume that if it makes sense logically, if you would say it to your friend in conversation, then that conclusion is probably rationally based off of the perception you think it is. So we'll move into the next part of the rule, the second prong. This is the simplest prong in order to overcome. It's the one prong I've actually never heard an objection to, but it's there and it's important, and it kind of underlies the entire purpose of the rules of evidence. So it's an important thing to know, and like if this rule makes sense to you, then you kind of have the general spirit of the rules of evidence and their entire purpose generally. So it's helpful to clearly understanding the witness's testimony, this being the opinion, or to determining a fact in issue. So that's the second prong. If someone's drawing any comparisons or associations with relevance that we discussed a few podcasts ago, then good for you, because that's essentially what this is. It's a relevance requirement. It's slightly different standard than what relevance is. The conclusion that's being drawn by this lay witness has to be helpful in understanding the witness's testimony or to determining the material facts or elements of the crime or whatever. But just to take a step back and look at its implications on the rules of evidence generally, I'll let Dan take it from here.
So the reason that witnesses are called on the most fundamental level, just in regular trial, not mock trial, is to get certain facts out. And when you get certain facts out, you want them to be presented in a way that whoever the trier of fact is can understand them. So, like Alex was saying, 701B is pretty similar. There are some parallels between it and relevance in that when you're presenting evidence or presenting testimony, it should be helpful, it should be clear, it should be relevant to the case at hand. And that's really all 701B is saying, is that when a lay witness is giving their opinion, it shouldn't be some weird, crazy, out of blue or out of thin air, like out in left field kind of opinion. It should be helpful, it should be understood, and it should be relevant to whatever the fact in issue is, whatever you're trying to determine. It should be helpful in making that a little more clear.
Perfect. And yeah, I think that, like I said before, it's really good to understand that rule, because especially when you get to more complex rules, it's important to have that grounding and understanding into what the rules of evidence as a whole are trying to do. So I think that this is actually a really good illustration of that, and Yeah, although in this particular instance, the relevancy requirement here doesn't really come up too often. Like I said, I have never had an objection in regards to it, but it's important to note that it is there. If an opinion isn't relevant, then even if it meets the A and C conclusions, it's not admissible in court. That kind of makes sense. So moving on into C, and this is actually where the bulk of objections under 701 come. Like I said, 701A has so many parallels with speculation that oftentimes it's just stash away a speculation or lack of personal knowledge. So when you're objecting to 701, you're objecting to an improper opinion, and it's improper for any of these reasons, the most common of which is 701C. The opinion is not based on scientific, technical, or other specialized knowledge within the scope of Rule 702. That within the scope of Rule 702, if you were listening carefully before, 702 is the rule that we use to establish whether a witness is an expert as defined previously. So when we're talking about scientific, technical, and specialized knowledge, those are words that are used frequently in talking about experts and the type of knowledge that they can testify to. Essentially, what this prong is saying, a lay witness without training and expertise that hasn't been qualified as an expert cannot talk and opine about the expert nature or the in-depth scientific and technical nature of things that is reserved to expert testimony, things that require a specialization or some sort of prior knowledge to really reach conclusions about. Knowing the specific speed at which a car is moving merely by seeing it requires such specialized knowledge, using Matt's prior example, that it cannot be ascertained by any lay witness as a rule. There are no exceptions. There are no perceptions that could really allow for that. I could imagine perhaps some strange scenario where the car has a giant odometer above it, like a taxi would have, and just displaying the speed. But even then, that's certainly ludicrous, and there's issues with the reliability of such an odometer regardless. So in general, to elicit such a specific conclusion that you can imagine requires something scientific or technical to really know. Because I'm sure a scientist could say, well, I have this video of this car moving across, and I can say by the amount of time it takes for it to cross the entire screen, the number of frames it takes, I can do mathematical calculations to determine what the speed is. Without that type of scientific or technical testimony, eliciting that specific mile per hour amount is not allowed. It's inadmissible. So that's kind of what Rule 701 is saying. Do you guys have anything else before in regards to 701C? I'm saying that.
No, I think we've covered it.
Yep.
Yeah, I think it's pretty clear. Like I said, that's the most common type of improper opinion. So I just want to talk briefly about practically how you're going to apply this. If you're sitting there watching a director, or as an attorney listening to the director cross, looking for things that might be objectionable or that you don't want to allow into the record, and you hear something that a lay witness is talking about specialized conclusions, much like Matt's example, the way you want to object is to say, "Objection, Your Honor. This testimony is an improper opinion and should be stricken," and obviously you'll go on and explain that this requires scientific and technical knowledge if you're asked for it by the judge, and you can have that argument, but that's kind of the wording you want to use. So this is an improper opinion. It's improper because it requires scientific, technical, specialized knowledge the witness has not been established to have. So before a witness can testify to those type of things, it requires some sort of foundation. That hasn't happened, therefore this conclusion is inadmissible as improper.
Okay.
Yep, I think we're pretty much there. What's an example, and I think we've probably touched on this enough, but give me one more example of something that is unscientific testimony that people might think is scientific. So like, what's something that's close, but not really? Like, what's a borderline example here? I can kind of think of one from Rock the World last year, namely Charlie Kaminsky.
Okay, then give that one.
Sure. The Charlie Kaminsky testifying that while he was on a ride that was being run, that it was being run faster than usual, or that it was being run, and that the further conclusion that probably crosses the line is it was being operated unsafely. So he kind of makes two conclusions in this one sentence, and I think it kind of illustrates the distinction between the two very well. So on one hand, he's ridden this ride in the past multiple times. He understands what it feels like, and he is saying that this ride felt different, namely it felt faster. That, you could say pretty simply, I think, is a rationally based perception. He perceives that it's moving faster because of how his body feels while undergoing that action, and the conclusion that it was going faster seems to be rationally based from that fact. Many people would object to that conclusion and say it required specialized knowledge, but much like the London Bennett example, if he has some reason to believe it, like if he was watching it or if he heard about it, like maybe those aren't really perceptions that lead to that conclusion, but because he was experiencing it pretty clearly, it's a perception that rationally leads to the conclusion that it was going faster. But the second conclusion, that it was being operated unsafely, seems not too far removed from that initial conclusion on first glance. But when approached with the same objection, you would respond by saying that that conclusion, that it was being operated unsafely, is based on scientific or technical knowledge. Namely, it implies that Charlie Kaminsky has some sort of knowledge about, one, the exact speed at which the ride was going, and the exact speed at which the ride should be going, and the exact speed at which the ride becomes unsafe to operate. None of which, without significant foundation and evidence that just didn't exist there, can be offered. Just that small little difference in the wording, it seems so innocuous, the difference between it was going fast and it was being operated unsafely, but the difference is huge in terms of the amount of knowledge and requisite scientific and technical skill required of the person who is making that conclusion. So because of that, sometimes this is a difficult objection to parse out. Just be careful of the distinctions, and just think to yourself whether this implies a certain amount of knowledge that the witness doesn't have, or if it directly states that a certain amount of knowledge is required, yet that foundation has not been laid. If either of those two things are true, then an opinion is improper. Because of 701C, it requires scientific or technical knowledge. I think with that, we're done with 701. It's a fun rule, and it kind of leads open into 702, which for a lot of people is the most is the richest of all the sections of the rules of evidence. So we'll be talking more about those later when we get into more in-depth analysis of the rules. Hopefully, and my goal is by the end of this that we have every single rule kind of covered in some capacity with a video. But 701 is really important, comes up a lot, and it kind of serves as the basis that you need before you jump into the expert rules of evidence. So like always, if you have questions or comments, leave them underneath the video. Myself, Matt, Dan, whoever's the president in the future, anyone in the program who has the knowledge to answer your question will surely answer it. And yeah, thanks for watching.